Hello everyone, this is your host Urvashi Chauhan. Welcome to Courts Today by Livelaw, your one-step destination to all legal developments in the country. Let us start. Starting with an update from the Supreme Court. Former Jharkhand Chief Minister Hemant Soren has approached the Apex Court against the High Court's dismissal of the challenge to his arrest by the Enforcement Directorate in the land scam case. The former CM had urged for an early listing of the matter considering that the election phase begins on 13th May. Last week, the Jharkhand High Court dismissed his plea challenging his arrest by the ED. This was 4 days after the Supreme Court agreed to hear his plea against the ED arrest. The High Court had also rejected his plea for interim bail but allowed him to participate in funeral rites of his uncle. Soren's counsel today requested the bench to give an early consideration to the SLP filed challenging the High Court's rejection, especially keeping in mind the election phase which will begin in the state of Jharkhand from 13th May and will last till 1st June. The bench of CJI D.Y. Chandrachud and comprising Justices J.B. Pardewala and Manoj Mishra was informed that the previous pending petition, that is against the ED arrest, is to be taken up by the bench of Justice Sanjeev Khanna tomorrow. The CJI then asked the senior counsel to circulate an email in this regard so that both matters may be listed together. The Supreme Court today granted anticipatory bail to Umar Ansari, son of gangster-turned-politician late Mukhtar Ansari. The anticipatory bail was granted in a case where Umar, along with other accused, was alleged to have threatened the district Mao administration and violated the Model Code of Conduct during the 2022 Uttar Pradesh Assembly polls. Ansari had approached the Supreme Court against the decision of the Allahabad High Court, which had refused to grant him anticipatory bail. Additional Advocate General Garima Prasad, appearing for the state of Uttar Pradesh, protested against the grant of anticipatory bail. She referred to the criminal history of Ansari by stating that he, along with other accused, including a crowd of 150 unknown people, had threatened the district administration of Mao. Ansari's counsel, Senior Advocate Kapil Sibal, submitted that the speech given during the election time was by Umar's brother Abbas Ansari and had led to registering of the case against him. He further pointed out that Abbas, who made the speech, and other co-accused had been granted regular bail. After hearing both the parties, the bench comprising Justices Rishikesh Roy and Prashant Kumar Mishra granted anticipatory bail to Ansari while noting that the charges framed against him are subject to adjudication in the trial. Umar has also been directed to cooperate with the investigation. In another update, Delhi court today denied bail to BRS leader Kavitha in the corruption and money laundering cases registered by the Central Bureau of Investigation and Enforcement Directorate related to the now scrapped liquor policy. Special Judge Kaveri Baveja of Rouse Avenue Courts passed the order and rejected Kavitha's regular bail plea in CBI and ED case. CBI has alleged that Sharath Reddy, the director of Aurobindo Pharma, participated in the liquor business in Delhi under the excise policy on Kavitha's assurance that she has contacts in the Delhi government and that she would help him in the business. It is further alleged that in November-December 2021, Kavitha asked Sharath Reddy to pay 25 crores at the rate of 5 crores per zone for the 5 retail zones allotted to him, as she had claimed that she herself had paid 100 crores as upfront money to Aam Aadmi Party through Vijay Nair for getting favourable provisions in the excise policy. Kavitha is presently under judicial custody in both CBI and ED cases. The Supreme Court today clarified that its order whereby it had directed reservation of minimum 1/3 seats for women in the Supreme Court Bar Association's Executive Committee is on an experimental basis and that any difficulty faced in implementing the reforms would be placed before the court. The matter was today mentioned by the office bearers of the lawyers' body. Senior Advocate Praveen H. Parekh mentioned that the general body was being called to declare whether the order of the court was valid or not. So last week, the bench of Justices Suryakant and K.V. Vishwanathan had made it clear that this reservation would also be applied in the coming elections, which are to be held on 16th May. Apart from that, it was also directed that in the upcoming elections, the post of Treasurer of the Supreme Court Bar Association shall be reserved for a woman candidate. After this direction, the SCBA passed a resolution on the very next day calling for an emergent general meeting on 7th of May, that is tomorrow. The resolution stated that there was no occasion for the Supreme Court to pass this order. The purpose of the meeting, as given in the resolution, was to discuss the nationwide consequences of such a suo motu amendment of Bar Association rules and also to decide the further course of action. The resolution also stated that as per this order, the independence of the bar had been impugned upon. Justice Kant today mentioned that a consent order had been passed. He referred to a statement made by the President of the Bar Association welcoming this order. He highlighted the importance of women representation and questioned the Bar Association's stance, suggesting that it should not claim superiority over the Indian Constitution. The bench also proposed that the association could bring the reforms. Significantly today, the Apex Court also recorded in its order that the emergency meeting, which was to be held tomorrow, that is on 7th May, would be cancelled now. The bench of Justices Bela M. Trivedi and Pankaj Mittal today was hearing Enforcement Directorate's plea against certain district collectors of Tamil Nadu over their non-appearance in relation to a sand mining money laundering case. If you remember, the Supreme Court in February this year had lifted a stay imposed by the Madras High Court on the ED summons against the district collectors of Tamil Nadu for investigating the matter. At the last hearing, the bench had criticized the officers for not complying with the ED summons and had granted them another opportunity to appear before the agency. Today, Senior Advocate Kapil Sibal, on behalf of the state of Tamil Nadu, informed the court that the district collectors had appeared before ED after the last hearing. When Advocate Zohaib Hussain, appearing for ED, said that though the collectors appeared, they did not furnish the documents asked for, Sibal replied saying that everything that the agency had asked for in the summons had been supplied. The court then relisted the matter and asked the Enforcement Directorate to file an affidavit saying that the documents it had asked for in the summons had not been supplied. During the hearing, Sibal also informed that the Enforcement Directorate officials called the concerned collectors at 11 a.m. and made them sit till 8:30 p.m. Deprecating this, the bench asked ED not to harass the collectors unnecessarily. The Gujarat High Court today pronounced judgment in the high-profile case of the murder of RTI activist Amit Jethwa. The court has acquitted the former BJP Member of Parliament Dinu Solanki and 6 others in the case. Jethwa, a lawyer, was shot dead for exposing illegal mining in and around the Gir Wildlife Sanctuary in which Solanki was involved through RTI applications. In 2010, he filed a PIL against the illegal mining in and around the Gir Sanctuary. He was shot dead outside the Gujarat High Court in July 2010. Initially, the Ahmedabad Police's crime branch investigated the case and gave Solanki a clean chit. But dissatisfied with the investigation, the High Court handed the case to CBI in the year 2013. During the trial, out of 196 witnesses, 106 turned out to be hostile. They did not support the CBI case. So Jethwa's father moved the High Court seeking a retrial, and a fresh trial was ordered in 2017. A special CBI court in Ahmedabad found the accused, that is Dinu Solanki, his nephew and 5 others guilty of murder, causing disappearance of evidence and criminal conspiracy under IPC. While delivering the judgment today, the bench of Justices A.S. Supeha and Vimal K. Vyas sternly observed that the investigation in the case, right from its inception, appeared to be an eyewash and that all efforts were made to ensure that the truth is buried forever. For more details, you can visit livelaw.in. Coming to an update on the Cash for Jobs scam and Senthil Balaji's bail plea. The Supreme Court today posted to 15th May the plea filed by MLA and former Minister V. Senthil Balaji against a Madras High Court order denying him bail in this money laundering case. Balaji currently faces allegations of organizing the collection of money for job promises within the department along with his personal assistants and brother. Numerous complaints were filed by candidates who paid money but did not secure the employment. Based on these allegations, the Enforcement Directorate arrested Balaji in June 2023. The bench of Justices Abhay S. Oak and Ujjal Bhoya today expressed the court's inclination to hear the matter but adjourned it as Solicitor General Tushar Mehta asserted that the hearing would take some time as it was a case of victims being won over with regard to which there were findings required to be shown. Balaji's counsel advocate Aramya Sundaram, on the other hand, pressed that Balaji had been in custody for about 328 days. Let me tell you that the Madras High Court, while denying bail, had also directed that the trial be completed within 3 months. Despite a prayer by senior advocate Sundaram, the court refused to stay the direction for expediting the trial. Last week on 1st May, around 100 schools in Delhi and the National Capital Region of India were emailed bomb threats. The emails were received by the schools around 4 a.m. in the morning, leading to immediate evacuation and closure of schools all over Delhi. Bomb squads and Delhi police teams investigated the schools and increased the security throughout the capital. According to the police, nothing suspicious was found and the event was labelled as a hoax. In this regard, the bench of Justice Subramaniam Prasad of the Delhi High Court was today dealing with a plea filed by advocate Arpit Bhargava, seeking a detailed action plan to deal with bomb threats in the schools to ensure safety and security of children, teachers and staff in the national capital. The plea states that there is no action plan at present to deal with such incidents. Delhi Government's counsel Santosh Kumar Tripathi told the court that the Delhi police had filed an affidavit stating that it has an SOP to deal with hoax and actual bomb threat calls. He said that there are around 5,500 schools in the national capital and it is difficult to deploy police personnel at every school. He further added that as per the SOP, once a bomb threat is received, the first step is for the school to inform the police and second step is evacuation of children. To this, the court remarked that the SOP is quite general in nature. The court was informed that mock drills are taking place in schools regularly and that every school has an evacuation plan. The court has sought response of the Delhi government and Delhi police on the nodal officers responsible for taking action in case they receive bomb threats at schools and the number of mock drills conducted in schools to ensure evacuation of children without panic. Justice Prasad also asked the authorities to indicate the number of schools in each zone and the time to be taken by the nodal officers for taking action in case of a bomb threat. This matter will now be heard on 16th May. Stay tuned. The Rajasthan High Court has denied bail to 3 persons accused of lynching a man booked for raping the minor daughter of one among them. The public prosecutor submitted that the 3 accused committed a serious offence by causing grave injuries to the deceased named Rohit by inflicting lathis, sariyas and Farsi blows, and that the police team was deliberately prevented from reaching the place of the incident to take the deceased Rohit to the hospital on time. If the police were able to take Rohit to hospital on time, he could have been saved. While denying the bail, the single-judge bench of Justice Anil Kumar Upman emphasized that the FIR lodged by police against the deceased Rohit for rape could not be used as a shield by the 3 accused persons for the purpose of bail in lynching. The court added that the practice of mob lynching could not be accepted in any civil society at any cost. And lastly, the Kerala High Court has permitted a 16-year-old rape victim studying in class 11 to medically terminate the pregnancy which reached 28 weeks of gestation. The court held that a rape victim cannot be forced to give birth to a child of a man who sexually assaulted her. Justice Kausar Edappagat held that denying permission to terminate such an unwanted pregnancy would be equal to imposing forced motherhood, and it would violate Article 21 of the Constitution. In this case, the victim was sexually abused by her lover, resulting in the unwanted pregnancy. A case was then registered against the man under IPC, the POCSO Act, and the SC/ST Act. Thank you for watching. If you wish to know more details about the cases I mentioned here, you can visit our website at www.livelaw.in. Stay ahead with quick legal updates only on Live Law. Do not forget to like, share and subscribe and support us. You can also support us by donating through the thanks button at the bottom of our videos or consider becoming a member at just 89 rupees per month.